Every day in the USA, people find themselves in court.
This is State of Kansas versus Brandon Michael Keating, case number 23 CR 446. Darren Patterson appears as defense counsel. Amber Norris appears for the state of Kansas. Mr. Keating appears from the Butler County Jail's Zoom location. This matter comes before the court at this time for further proceedings. Seeing a whole stack of paperwork in this file which relates to bench warrant and bond forfeitures. I also see a warrant to show cause that was filed back in May of 2024. Who is representing the Court Services Department on this?
I am, Your Honor.
All right. Are we proceeding under Kit Russell's warrant to show cause dated May 28th of 2024? Or approximately around that time?
Yes, Your Honor.
Okay. Allegations of failure to report, failing to pay on his case as directed, failing to successfully complete the treatment recommendations from his drug and alcohol evaluation. How does your client desire to proceed here, Mr. Patterson?
Your Honor, I have discussed each of those allegations with my client. I would tell the court he is going to waive hearing and stipulate that he did violate the probation as listed.
All right, Mr. Keating, you heard your attorney's announcement. It's my understanding that you would waive any due process hearing that you'd otherwise be entitled to, where the state would have the obligation of proving these allegations by a preponderance of the evidence. You could challenge the state's evidence with the assistance of your lawyer, present your own evidence, confront the state's witnesses unless good cause was shown, and among other lesser remedies, the court could consider just an outright revocation and having you serve the remaining balance of this sentence locked up. Do you understand these things?
Sir.
Do you waive a hearing in this case and stipulate and agree that you committed the violations as the court enumerated earlier?
Yes, sir.
All right. Court finds that the defendant has knowingly waived his right to a hearing, stipulate and agrees that he committed the violations as alleged in the warrant to show cause of failing to report, failing to pay, and failing to successfully complete his treatment. The court will now turn to disposition, finding that those are substantial and material violations, starting with recommendations from the state. Ms. Norris.
Thank you, Your Honor. This is defendant's second warrant to show cause in this case. He was before the court last December 22nd, 2023 for a show cause where the court did give him a 30-day jail sanction. I believe he had previously had a 2-day dip sanction prior to that. Your Honor, at this point, state would be requesting a defendant's probation be revoked outright. He has, as of this date, 55 days of jail time credit, and the underlying sentence in this case is 6 months in the county jail.
All right. Mr. Ronas, representing the Court Services Department in this case, do you have any independent recommendations to make?
Not at this time, Your Honor.
All right, Mr. Patterson, your presentation to the court.
Thank you, Judge. Judge, I'll just start off by telling the court, after talking to my client, discussing the case as well as the history of the case, there will not be a request to reinstate probation here. That my client understands very clearly that he did mess up, that he has not been a good probationer. And in making this presentation, I just want to briefly go over the case a little bit with the court. That this is a crime that occurred September 11, 2023. That the charge was criminal damage to property. It was the breaking of a van passenger door window. That it was charged as a Class B misdemeanor with a 6-month maximum term allowed. That 2 days later, my client appeared at a first appearance, that he did not want to set it for trial, did not want to set it for anything else without counsel, He just entered a plea of guilty to the charge. Now, the attorney at the first appearance recommended 6 months. He received a 6-month sentence and then placed on 1-year probation. I would assume there was a waiver of counsel. I don't know that. It's not filed in the court file. It's not in the journal entry of sentencing, but I'm very familiar with the courts here, and I know that they do go over that. So he did it without counsel. And he was given the maximum sentence for this side van window. Judge, I can tell the court, as an attorney who's done these cases for decades now, a plea bargain is not, I'll plead guilty and get a maximum sentence. That in a case like this, if I was there, I would have been recommending a plea bargain of pleading guilty and a 90-day sentence. That is a plea bargain. But that was not done here. He just decided to move on with himself. He did not last long on probation, Judge, to be honest. And that's partly why my client and I talked about that he was a poor probationer. In October of 2023 was his first probation violation. So very quickly he did a 30-day sanction that was discussed, and then was placed back on probation. And then again, as the court noted, May 20 was the second violation. Judge, what we are asking the court to consider doing here is what the court is allowed to do is order that he serve a modified sentence. We would be asking the court that he serve a 90-day sentence with credit for time. And as Ms. Norris has stated, and I've reviewed it too and looked at it, he does have 55 days credit as of today, which if the court adopted our recommendation, that would mean he would have 45 days. He still has to sit in there. So we're asking the court to consider a modified sentence and order that he serve with credit for time. Thank you.
My math would indicate 35 more days.
And I'm sure you're right, Judge. I'm not a mathematician. So, okay.
All right. Does Mr. Keating have other holds on him?
Not that I'm aware of, Judge. I went back through the portal, and he really doesn't have much of a history except some traffic. So at least that I have available to me by looking up the state of Kansas portal. So I didn't see any holds on him in other cases in the state of Kansas.
All right, to address one concern, Mr. Patterson, this court presided over his first appearance. The docket notes clearly indicate that he waived counsel, and quite frankly, I don't think I would have accepted a plea unless I was satisfied that he had knowingly waived his right to counsel in the case. He decided to proceed on his own, received a very favorable sentence at the time, but I do understand your comments regarding the maximum sentence that was recommended by the prosecutor's office and subsequently imposed by the court. He hasn't been a successful probationer, to be sure. Does the state take a position on what you may or may not have been anticipating to be a request, which was for a reduced sentence, Ms. Norris?
Your Honor, I did expect that the council would probably request that if the court was so inclined, I'd ask that the court, maybe give him 5 months or 4 months, because he has, like I said, he already has 55 days of jail time credit. So he would serve more, if not the full 6 months in the county jail.
Mr. Keating, the court's hope was obviously that you just be successful on probation. You weren't. At least you acknowledge that you weren't, and you're willing to sit in jail like a man and do your time. While you really haven't earned any type of reduction of sentence in this case, I am somewhat influenced by Mr. Patterson's recommendations. This is why you probably should have had an attorney on your case to start with. You can see what kind of job of advocacy Mr. Patterson has done today to try to help you with a very difficult situation, and you would have benefited from that in the beginning, but you wanted to waive counsel and get it over with. With that said, the court, in many instances when there's egregious violation of probation conditions, one option that the court has is to order 60 days in the county jail as condition of reinstatement. The court's not going to waste any more time of a probation department with you. You're not going to be successful. However, this court will exercise its discretion under KSA 223716 to reduce your sentence after you serve 60 days more. In other words, a total of 115 days. The court will consider your case flattened and order you released on this case. Now, that's far, far less than an outright revocation would have meant for you, Mr. Keating. You'll get out about the time the weather gets warm again. I hope, anyway, because I'm quite frankly pretty tired of the cold stuff. In that 60 days that you have to serve starting today, before you can complete your sentence, Mr. Keating, I just hope you just think about the mistakes you've made and ways that when you get out, you can avoid making those same mistakes in the future. I'm not going to assess any more fees, despite the fact that Mr. Patterson's services have obviously been valuable. I just think that you don't have any capacity to work right now, and I'm going to waive any additional assessments in the case. Anything that has been assessed in the past and not fully paid obviously can be sent to collections. It's immediately due and payable and collectible. All right, Ms. Norris, do you need any further clarification on the court's order made here today? Okay, I think you said no when you were muted.
Sorry, no, Your Honor. Thank you.
All right. Mr. Patterson, is there anything further from your perspective that we need to address regarding Mr. Keating?
No, Your Honor, thank you.
All right. Then if there's nothing further, then the Brandon Michael Keating matter will be in recess. Mr. Keating is remanded back to the custody of the sheriff's office in the jail to serve 60 additional days before release.
And Your Honor, I believe that's my only case. May I be excused?
You are at this time, Mr. Patterson.
Thank you, Judge. Have a good day.
2.